Well, hi everybody. Welcome back to part 6 of our look at the article that was written by Michael Cicchini for the Oklahoma Law Review. Let's just pop it straight up and let's crack on. We've not got far to the end now. I think we're at page 3756. So hopefully another 2 more parts and we should have this done and dusted. Let's do that and move me out of the way up here. And so chapter 4, a simple plan. As demonstrated above, reacting to prosecutorial misconduct after the fact via a contemporaneous objection is often ineffective. Therefore, defense counsel should consider formulating a plan for dealing with improper remarks long before the prosecutor utters them in closing argument. A. Plan objectives. Defense counsel's plan for dealing with improper closing arguments should ideally accomplish several objectives. First, the plan should deter the prosecutor from making improper arguments in the first place by putting the prosecutor on the defensive. Although one would hope that the court system and the judges would have already done that, but as we've seen far too often, they seem to be in cahoots. The plan should have a chilling effect on closing argument rhetoric and should make the prosecutor fearful for reprisal for making improper arguments. Second, in the event the prosecutor is not deterred, the plan should educate the trial judge by describing what the prosecutor is likely to argue and explaining why such argument is improper. This way, the trial judge is alert and engaged during closing arguments, making it more likely he or she will recognize an improper argument in the first place, a prerequisite if the defendant is to obtain any meaningful relief. Third, the plan should adequately preserve the prosecutor's misconduct for meaningful judicial review during trial and, if necessary, at post-conviction hearings and on appeal. Thus, the plan should prevent the shifting of blame from the prosecutor to defense counsel via the ineffective assistance of counsel framework, and should prevent the courts from sidestepping the issue by applying the plain error framework, which, as noted above, is incredibly difficult to satisfy. Moreover, given the demanding and potentially harmful nature of the normally required contemporaneous objection, the plan should preserve the prosecutor's misconduct for judicial review without defense counsel having to object in the middle of closing arguments. Fourth, the plan should provide defense counsel and the trial court with an opportunity to develop effective curative instructions for the prosecutor's misconduct. Just as it is difficult for defense counsel to identify improper arguments and instantly formulate an objection in the heat of battle, so too is it difficult for even a well-educated and attentive trial judge to craft a meaningful curative instruction on the spot. Fifth, in the event that curative instructions are not sufficient to cure the prosecutor's misconduct, the plan should give defense counsel the opportunity to consult with the defendant before requesting the serious and costly remedy of a mistrial. In cases with multiple improper arguments, it should also give the trial judge the opportunity to assess the cumulative impact of the misconduct before ruling on the mistrial motion. Finally, in the event a mistrial is requested and declared, the plan should lay a foundation for defense counsel to later argue that double jeopardy protections prevent the state from re-prosecuting the defendant in a second trial. B. Pre-trial motion in eliminate. In order to accomplish the above objectives, the battle must be won before it is fought. That is, before closing arguments begin. A motion in limine, which is filed before trial and seeks an advanced ruling on an issue likely to arise during the trial, can accomplish this goal. Motions in limine promote trial efficiency, and their use has expanded in recent years. Given the disruption caused at trial by prosecutorial misconduct in closing arguments and the dearth of suitable remedies, once the misconduct occurs, the issue of improper prosecutorial arguments is undoubtedly appropriate for a motion in limine. More specifically, if defense counsel suspects that the prosecutor intends to make improper statements during closing argument, the defense counsel should consider filing a motion in limine before trial, asking the trial judge to preclude the prosecutor from making those arguments. If this motion is granted, it could solve the biggest problem facing defense counsel at trial in many jurisdictions, as long as the motion alerts the trial judge to the same issue of fact or law that arises at trial. Then the motion in limine relieves the party from having to object. This makes sense, of course, as the very purpose of raising the issue before trial is to avoid having to object and draw more attention to the improper argument during trial. To require an objection at trial to something already raised in a motion in limine would put counsel in a classic catch-22 position. By not objecting, counsel is held to waiver. By objecting, counsel draws the jury's attention to the very prejudicial argument that the trial court had already ruled improper. As one court stated, because the purpose of the contemporaneous objection rule is fairness, we will not apply the rule to permit such an unfair dilemma. In jurisdictions where the motion in limine, if granted, serves as a legally valid substitute for the contemporaneous objection, this approach should also satisfy another objective. It preserves the prosecutor's misconduct for meaningful review at all levels, including during post-conviction hearings and on appeal. And the motion in limine will serve to focus the attention of post-conviction counsel and the courts on the prosecutor's misconduct rather than on the defense lawyer's failure to properly react to the improper arguments. In order to accomplish the objectives related to remedies, however, the motion in limine must go beyond merely asking the court to order the prosecutor not to make certain types of improper arguments. Rather, the motion must assume the prosecutor will violate the court's order and should therefore propose a course of action with regard to the two most common remedies: curative instructions and a mistrial. As previously discussed, many types of improper arguments can be adequately addressed by curative instructions. In order to allow sufficient time to draft instructions tailored to the specific prosecutorial offence, though, the motion should request a hearing for that purpose outside the jury's presence. The hearing should be held after the prosecutor's rebuttal argument and before the court issues its final instructions to the jury. Then, to allow defense counsel an opportunity to consult with the defendant before requesting a mistrial, the motion should preserve the right to request the mistrial until after the court's final instructions to the jury and before the jury returns its verdict. Finally, in the event the court grants a mistrial motion, the previously filed motion in limine may also help accomplish the final objective discussed above, offering protection when the prosecutor attempts to retry the defendant. Although highly state-specific, the test for whether the prosecutor may retry the defendant may hinge on whether the prosecutor goaded defense counsel into requesting the mistrial. If so, then retrial is barred. This high standard is much easier to satisfy when defense counsel previously put the prosecutor on notice via the motion in limine that improper arguments would provoke a mistrial request. See trial procedure. After filing a motion in limine, defense counsel must also have a plan for the trial itself. This requires researching the applicable procedural laws, including, for example, any timing requirements for requesting the available remedies. At a minimum, defense counsel should be prepared for the following 3 steps. Fair enough. 1. Decide whether to object. In many jurisdictions, assuming the trial judge granted the motion in limine before trial and the prosecutor violated the court's order by making an improper argument, no contemporaneous objection by defense counsel should be required. There are still several scenarios, however, where defense counsel will be required to object. First, when the trial judge denied the motion as being premature, refused to rule on the motion, or responded to the motion in a vague way, for example, by stating that the lawyers will be expected to follow the rules during closing arguments. Defense counsel will be required to object to the prosecutor's misconduct as it occurs. In this case, the motion in limine will have failed to fulfill one of its objectives to relieve defense counsel of the duty to object in the middle of closing arguments. Simply filing the motion in limine, however, will still accomplish many other objectives. Second, if the judge granted the motion in limine, defense counsel will still be held to the contemporaneous objection rule when the prosecutor makes an improper argument that was not identified in the motion. This is so because the judge did not have the opportunity to order the prosecutor not to commit that particular brand of misconduct. Third, even when defense counsel has identified a particular type of improper argument in the motion in limine and the judge granted the motion, counsel may still want to object in cases where the objection might terminate the argument before the prosecutor completes a full wind-up and delivery. Therefore, the motion in limine should preserve counsel's right to object, even though the motion in limine relieves counsel of the obligation to object. Number 2, request a post-argument hearing. Assume then that the prosecutor makes an improper argument to the jury, regardless of whether defense counsel A, identified the issue in the motion in limine, which the court granted, or B, contemporaneously objected at trial. The next step after the state's rebuttal argument is to quickly request a conference to be held outside the jury's presence and before the court gives its final instructions to the jury. At this conference, defense counsel should identify the prosecutor's improper argument and propose curative instructions to be included with the court's final pre-deliberation instructions. Curative instructions will vary dramatically based on the prosecutor's specific form of misconduct. 3, consider a mistrial motion. Once the jury receives its final instructions, including any curative instructions, and begins its deliberations, defense counsel must next discuss with the defendant the possibility of a motion for a mistrial. The mistrial is the only remedy certain to ensure that the prejudicial conduct will not taint the ultimate verdict. Obtaining this remedy, however, may unfairly burden the defendant. During the discussion, defense counsel should explain the possibility or likelihood of retrial, as well as other consequences, including a lengthy delay, continued incarceration, additional attorney's fees, and other trial expenses, and most significantly, the possibility of the state developing a stronger case for the second trial. Not requesting a mistrial, however, also has consequences that defense counsel should explain. Most significantly, the appellate court will likely decide that the defendant was happy with merely receiving a sustained objection and curative instruction, if any, and decided to roll the dice on the verdict. Counsel should be sure to explain that in this scenario, the defendant's post-conviction counsel may be forced to seek relief through the difficult to satisfy plain error framework. Any mistrial motion should be tailored to the specific jurisdiction's multi-factor mistrial test. Additionally, to support any future motion that the prosecutor should be barred from retrying the defendant, counsel may wish to state that 1, the prosecutor was put on notice via the pretrial motion in limine, regardless of whether the court granted it, that a particular argument was improper and would provoke a mistrial request. 2, the prosecutor decided to make that improper argument despite such notice. And 3, the prosecutor has therefore provoked defense counsel into requesting a mistrial. The other mistrial related issues. With regard to mistrial motions, two highly jurisdiction-specific issues arise that defence counsel should research, consider and discuss with the defendant before trial and even before filing a motion in limine. Who has the power to request a mistrial and when must the court rule on a mistrial request? First, if the lawyer and client disagree on whether to request a mistrial, with whom does the decision rest? Most attorneys, trial judges, and even appellate courts do not know the answer. In one case, a trial judge offered the defendant the opportunity for a mistrial and told him that while the decision was his, he should seriously consider his attorney's advice. After lengthy consultation with defence counsel, the defendant elected not to follow his attorney's advice to request a mistrial and instead proceeded to verdict. The defendant was convicted. On appeal, the defendant argued that this was a strategic decision that should have been left to counsel. Such a decision, the defendant argued, did not fall into the category of fundamental decisions that are reserved for the client, such as whether to enter a plea or to go to trial, and if there is a trial, whether to testify. The court stated that it was an intriguing and sophisticated question as to whether defence counsel or the defendant should be permitted to make a mistrial decision. The court never truly disagreed with the defendant, thereby implying that the decision might actually rest with counsel, as the defendant had argued on appeal. The court, however, dispensed with the issue of employing the doctrines of waiver and judicial estoppel. But even if the mistrial decision is, in theory, left to the lawyer, it is often, probably always, intertwined with decisions that are left to the defendant. For example, the defendant has the constitutional right to counsel of choice. But what if the defendant could not afford to pay his lawyer for a second trial and would instead have to obtain state or court-appointed counsel for the retrial? In that case, wouldn't a mistrial request implicate a constitutional right? And shouldn't the decision whether to ask for a mistrial be left to the defendant? Similarly, many defendants are unable to post bail and therefore must remain incarcerated during their cases, a key reason that a defendant has a constitutional right to a speedy trial. But what if, due to court congestion, unavailable witnesses, or some other reason, a mistrial would result in a long delay? In that case, wouldn't a mistrial request implicate yet another constitutional right? And once again, shouldn't the decision whether to ask for a mistrial be left to the defendant? For these decisions, one appellate court offered valuable advice, which may prove useful for defence attorneys. Faced with the dilemma of this disagreement between client and attorney, the trial court did the only prudent thing. It urged the defendant to follow the attorney's advice and advised the defendant that his lawyer was the person better equipped to make this decision. Second, while defence counsel's motion for a mistrial likely must be made before the jury returns its verdict, or sooner in some jurisdictions, when must the court rule on the motion? In some states, a trial court may declare a mistrial up to the point the jury's verdict is accepted. A jury's verdict is not accepted until it is received in open court, the results announced, the jury polled if requested, and the judgment entered. Such timing would be ideal for the defendant. If the jury verdict is not guilty, defence counsel simply withdraws the mistrial motion and instead moves for judgment on the verdict. This timing removes the risks associated with asking for a mistrial. While this may seem like an unfair advantage for the defendant, not sure about that, it is actually the only fair way to proceed. After all, it was the prosecutor's misconduct, not that of the defendant or defence counsel, that provoked the mistrial motion in the first place. Why should the prosecutor's improper behaviour force the defendant to choose between two unattractive alternatives, a tainted verdict or a costly retrial? Fairness and efficiency require that the jury be allowed to return its verdict before any determination is made as to whether a mistrial and potential retrial are even necessary. The question then becomes whether defence counsel has any influence over the timing of the court's ruling. Council may consider coupling a mistrial motion with the request that the court defer its ruling until after the jury returns its verdict, stressing the fairness and efficiency-based arguments set forth above. Alternatively, council may wish to proceed such timing in the motion eliminate itself, thus obtaining an advanced ruling on the issue. Such a ruling would in turn allow council to more freely request a mistrial, as there would be no risk to the defendant in doing so. But we'll just do this paragraph and that will be it. But would a trial court be less likely to grant a mistrial request after the jury returns a guilty verdict? And would an appellate court later turn defense counsel's request for a deferred ruling against the defendant, finding that it somehow qualified or even negated the motion itself? After all, courts have demonstrated beyond any doubt that they will break clean through the boundaries of logic, reason, and fairness in order to affirm defendant's convictions. So we've just got the conclusion to go. So maybe got another 10 pages. So hope you're enjoying this excellent series. Obviously, if you've missed the first 5 parts, you particularly need to look at the section where Michael Cicchini outlines the various bad practices by prosecutors. And as I say, when it comes to Ken Kratz, you can rest assured, when you read through all of the different categories of prosecutorial misconduct, he well and truly ticks every single box. Anyway, thank you all for tuning in. We'll catch you all again soon with what should be the final part, possibly tomorrow or Wednesday. Catch you soon. Bye for now.